Welcome everyone to the Asian Regional Summit, which is happening today, and tomorrow the Philippine National Conference on the British Institute of International and Comparative Law, or BIICL, Corporate Climate Litigation. So to give the welcome remarks is the Dean of the UP College of Law, our beloved Darlene Marie B. Berberabe.
Thank you very much, Professor Froy. Good morning and welcome. Thank you for your presence, Honorable Supreme Court Saj Marvic Leonen, Dr. Ivano Alogna, and the esteemed panelists for today. Good morning and welcome to the Asian Regional Summit and Philippine National Conference on the British Institute of International and Comparative Law Global Toolbox on Corporate Climate Litigation. This two-day seminar is co-organized by the UP Institute of International Legal Studies, UP Law Center Information and Publication Division, BIICL, Commission on Human Rights, and Asian Development Bank. The World Meteorological Organization predicts an annual average global temperature exceeding 1.5 degrees Celsius, which means temporary breaches of the goal set in the Paris Agreement, where it was agreed that efforts would be pursued to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels. Global warming could lead to far more severe climate change impacts. Thus, this seminar on climate change litigation is timely, and we are privileged to have with us Senior Associate Justice Marvic Leonen, who co-founded public interest groups advocating for the rights of marginalized groups who are most affected by climate change. Saj Leonen is also the head of the Supreme Court's Committee on Sustainability and Environmental Concerns. Thousands of climate change-related cases have been filed against states and against private actors which have been major greenhouse gas emitters, such as fossil fuel and cement companies. The BIICL has undertaken a research project that examines the unique aspects of climate litigation across the corporate world and has produced the Global Toolbox on Corporate Climate Litigation, which will be presented by BIICL's research leader, Dr. Ivano Alogna. The climate change impact of corporate activities and sources of corporate accountability will be examined by a panel that will be chaired by UP College of Law Assistant Professor Mike Q, who is also BIICL's National Rapporteur for the Philippines. The panel consists of scientists, judges, environmental lawyers, and academics. This afternoon, the chairperson of the Philippine Competition on Human Rights will give a message on climate change and human rights with corresponding reactions from environmental NGOs and the UP Law Institute of Human Rights. Three separate other panels will discuss the remedies, procedure, and evidence involved in suing corporations for climate change contribution. Finally, the last session will inform judges about the issues around corporate climate litigation. We in the UP College of Law are excited to have this interdisciplinary seminar as perspectives of government, litigation, and environmental lawyers, judges, scientists, researchers, and academics will be presented. The seminar also promises to be comprehensive and pragmatic because, in addition to the policy discussions on the impact of corporate actions on climate change, there will be discussions about remedies, procedure, and evidence in filing cases against corporations by speakers both from the Philippines and abroad who have worked with people and communities who have been affected by the adverse effects of climate change. Once again, welcome.
Thank you so much, Dean. And now, let's move on and hear from Dr. Ivano Alogna. He is going to give a background of the project and he is going to present the BIICL Global Toolbox. He's going to be joining us online. And Dr. Alogna joined BIICL in 2019 and is the research leader in environmental and climate change law at BIICL. He is an associate member of the Sorbonne Research Institute in International and European Law and contributes to global environmental discussions as a member of the World Commission on Environmental Law of the International Union for the Conservation of Nature, serving on its climate change expert group and task force on the rights of nature. He is also an expert of the Environmental Law and Policy Commission, IUCN French Committee. Dr. Ivano played a pivotal role as the General Rapporteur of the Global Pact for the Environment project, led by the French Constitutional Council, and participated in the European Law Institute project Ecocide. So, ladies and gentlemen, joining us online is Dr. Ivano.
Good morning, everyone. Thank you very much for this introduction. Today, on behalf of the Institute, I'm really delighted to welcome those in person at the University of the Philippines College of Law and everybody joining us online remotely for this extraordinary event, the Asian Regional Summit and the Philippine National Conference of the Global Toolbox on Corporate Climate Litigation. With this introduction today, I will provide some background on the project that brought us today here. So just a short outline. I start with an introduction on BIICL, something about the corporate climate litigation terminology we are using in this project, its scientific basis. We are just going to give a glance to what is an increasing phenomenon, and then I will sketch some remarks on the project and on the Global Toolbox on Corporate Climate Litigation itself. So just let me start by saying a few words about the British Institute of International Comparative Law, as we say, BIICL. So the institute was created in 1958 by the merger of the Society of Comparative Legislation and the Gross Use Society, and the initial signatories established an independent research body unaffiliated to any university, which was committed to the understanding, development, and practical application of international comparative law. And the founders of BIICL were a group of individuals with a wide range of legal interests and experience, including some of the most illustrious legal minds of their time. You will probably know Baron Denning and Hersch Lauterbach. So, as many of you surely know, BIICL today is a prominent research institute focusing on the range of areas within international and comparative law, as well as the rule of law. And these are the key areas of work that constitute the main focus of the three centers that form the institute. So we have the Center for International Law, the Center for Comparative Law, and the Bingham Center for the Rule of Law. And our works covers a broad range of issues, including business human rights, migration, trade and investment, competition, product liability, cultural heritage, and of course, environmental and climate change law. So across all of these, we undertake applied research. We publish legal literature in the field, such as our International and Comparative Law Quarterly. We convene forums, conference events, and organize also training opportunities for professionals. And as you will see if you visit our website in the latest year, BIICL has also been working extensively in relation to climate change litigation, which is, as you know, a critical component of today's global governance to tackle climate change. So, before going into details on the project, let me just provide some pointers on the field that we have been exploring in the last years, notably the corporate aspect of climate litigation. So you see on the slide, there are some publications led by our institute. a couple of books, edited volume on climate change litigation, global perspective, and climate litigation in Europe, and some other works related to this particular aspect of climate litigation. So, first of all, an important caveat on the terminology we use. As you all know, private companies are undoubtedly a critical part of this super weak problem. As you know, time is running out. There is no central authority to tackle it. And also those seeking to end the problem of climate change are also the ones that are causing it. However, when we talk about companies, they are also, and they might also provide the means to mitigate this problem, especially in the context of the current much needed energy, ecological and just transition. And that's why talking about corporate climate litigation allows to avoid the contraposition between NGOs, citizens and local communities, or even governments on one side, and the private companies on the other one. So this will consider the corporation as fundamental actors in the fight against climate change. And that's why we prefer to talk about litigation involving companies rather than just against them. But unfortunately, this is not the only reason for this possible choice of terminology. In fact, we are currently witnessing cases where companies are invoking the courts to contrast the claimants with SLAPP. So these are the lawsuits where fossil fuel giants allege damages for defamation against the NGOs in an attempt to counter the legal campaign. And these lawsuits are utilized as corporate tactics to suppress criticism by hindering public protest, by draining also economic resources from the defendants. And this kind of SLAPP have been used in different parts of the world, such as in a case brought by Total against Greenpeace in France, where last year in April, the fossil fuel giant Total filed a lawsuit against Greenpeace over a report claiming the company massively underestimated its 2019 greenhouse gas emissions. So Total Energies asked the civil court to order Greenpeace France to delay the report and all the related publication. They asked also to a fine of 2,000 euros per day, and they requested also the Greenpeace France be ordered to pay a symbolic €1 in damages and 50,000 euros in legal costs. I'm glad, I would say, to tell, because the Total summons was dismissed a few months ago by the Paris Judicial Court at the end of April. So in a way, we see this is also an example of this kind of litigation. And in a way, this shows just a part of the very complex picture of climate litigation involving private companies that we are going to explore all together in these 2 days. Particularly, we're talking about the carbon majors, of course, the major greenhouse gas emitters, which are mostly fossil fuel and cement companies, which were already identified in 2014 by Richard Heady and the Climate Accountability Institute through an assessment of the historical contribution of these companies to greenhouse gas emissions. You can see this is the report that I have on the slide. This group of scientists at the Climate Accountability Institute attributed 63% of the carbon dioxide and methane emitted between the year 1850 to 2010 to a mere 90 entities. So that shows also the importance of these kind of companies. And with this kind of data brought together by the Climate Accountability Institute, the climate scientists today can run climate models to calculate, among other things, the amount of global average surface temperature, and, for example, also the sea level rise is linked to the emission from a carbon producer. We are going to talk about this when we are going to talk about attribution science, And this is really a new, very critical field of science that is growing rapidly with advances in that have been tracked by many groups of scientists around the world that are involved directly in this kind of litigation. I just mentioned in the slide a few of them. There is Oxford University, of course, Columbia University, and there is also the UCS, the Union of Concerned Scientists, but we really are finding this kind of study a little bit everywhere around the world. And last summer, let me just also mention another work by Ricchidi, who is part of our core group, and Marco Grasso, an Italian scholar. They published this new research quantifying and highlighting that the world's top fossil fuel companies owe at last $209 billion in annual climate reparation to compensate communities most damaged by their activities. So this shows also a little bit the substance of this kind of impact and possibly of the litigation. And I just finished on this scientific basis by drawing an interesting parallel, which was made with tobacco litigation and has been highlighted by some scientists. In particular, we have another component of our core group, the Harvard professor of science, Naomi Oreskes, who in her book Merchants of Doubt, written with Eric Conway, showed the similarities between tobacco industry on one side and its disinformation campaign and the fossil fuel industry current effort to sow confusion about climate change. So both industries have adopted a strategy of disseminating disinformation to manufacture uncertainty. That's why the title of the book, Merchants of Doubt, and also forestall governmental action. And in so doing, they have placed corporate interest above the public interest. So in recent years, there has been a surge in climate litigation, and not only against the fossil fuels firm, but also against other polluting industries, with many cases challenges corporate inaction on the climate crisis, and also, as already said, attempts to spread misinformation. And we can say that companies today are increasingly recognizing this as a risk. As you can see on the slide, the Sabin Center for Climate Change at Columbia University databases currently takes into account more than 200 cases worldwide, without even counting the cases in the US, where we found some of the very first cases brought against corporations. Notably, for example, you see on the screen the village of Kivalina versus ExxonMobil in 2012, but also other cases brought by states against utility companies and against automotive companies. And many of these initial cases, as you can see, they failed against the political, under the political question doctrine, or were preempted by federal statutes such as the Cleaner Act in the US. So these are a very important legal system in the US because, as you probably know, we have there 3/4 of the cases that have been filed around the world. And in a way, in the last decades, the target for climate litigation continued to extended beyond carbon-intensive industries. And in addition to the continuing trend in cases concerning a company's contribution to climate change through their greenhouse gas emissions, there are other types of claims against businesses across various sectors that began to emerge. And these, as you can see on the slide, included claims concerning director duties. There is a case that now has been quite famous, the Client Earth versus Shell, not successful one, but very interesting one. And also a case on the company's obligation to adequately disclose the financial risk of exposure to climate change brought about by their business activities. So this is an evolving landscape of litigation against government also that is contributing to this panorama of climate litigation, and in a way is triggering further legal and policy changes which have ripple effect, we can say, across the private sector. And so we have high emitting sectors also that continue to be the most exposed to transition risk, including climate litigation and related legal and policy risk. Carbon intensive project proposal that fail to address climate impacts and respond to sustainability concern could face not only these litigation preventing their development, but as you probably heard, as you also seen, we also see that there is the risk of divestment of capital from lenders, from investors, and there is a concrete risk of reputational damage, which is sometimes one of the most interesting aspects of this kind of litigation. So the strategic side of it. And yeah, so in the last year, we are witnessing also with this project to an always more important extension of corporate climate litigation to new areas, new challenges, and to what we can call an always more creative use of different causes of action and legal strategies. This is something that we are going to see already in the first panel today. And sorry, at the bottom of the slide, I propose you a recent open access contribution that highlights the increase in this kind of litigation. And this is really the heterogeneity of this case in the field, their importance, the fast development that are at the basis of the project that we are presenting here today. So this is the actual original name of the project, Global Perspectives and Corporate Climate Legal Tactics. You can scan the QR code embedded in this slide to access the project's webpage. And we started this project in September 2022 as a comparative project to study the possible avenues, the hurdles, and the prospects for this kind of litigation. Taking stock of legal experiences and tools in the different countries around the world to discuss innovative possibilities. And just a few months ago, in March, at the end of March, on the 27th, we presented in London the fruit of this journey, what we call the Global Toolbox on Corporate Climate Litigation, an evolving, collaborative, and open access platform designed to keep NGOs, companies, government entities, local communities, and legal professionals generally with a diverse set of instruments tailored for corporate climate litigation. So just show us, let me show you our goals. They are clear. We want to map corporate climate litigation globally, to catalog pivotal cases, to foster, of course, strategic thought, which might be helpful in litigation planning. And also, in a way, this, I think, is one of the most important to motivate corporate change through raised awareness of climate litigation risk. And so we have integrated to doing so insights from the 17 national reports and expertise from a core group of internationally recognized experts, both from the Global South and the Global North. And you can see some of them. So this is the core group. As you can see, we have academics from China, from the US, from Australia, some of the most important academics in this field, like Professor Chin-Tian Pao, Professor Michael Gerard from New York University, from Columbia University, Professor Jackie Peel. We have from Melbourne University. We have also very important scholars, judges like Justice Preston in Australia. We have, as I said before, Rikidi and Naomi Reskes from the US as scientists, Emmanuel Gireshabuya from now Minister of Justice in Rwanda. We have really a panel of great experts that are working in different areas that are related to this field, and in a way that advise us on the methodology and support us in the development of this project. And of course, the most important part of our project, the comparative aspect, the 17 countries that you see here in every continent. As I told you, the international expert group, which is made of more than 200 experts worldwide, is really what made this project possible, with offering us the experience from 17 different countries around the world, ensuring also, I would say, a rich tapestry of perspective, benefiting from the wisdom of the judiciary, from legal practice, academia, each one of them having contributed to our work during national and comparative workshops, public events, discussion, consultation, and also reviews of the different sections of the toolbox that I hope you are going to see and discover with us today and tomorrow. And these are some of the outputs of our project. As part of this project, we created the corporate climate litigation platform that is composed by 3 parts, as you can see on the slide. So there is the CCL resources, that is a rich collaborative repository of literature and references in this field, which is still growing every day, every week. We are adding new references. Then there is a work in progress, what we call the CCL database. So that will be, when it will be disclosed, a user-friendly AI-powered database, which is in development in collaboration with Climate Policy Radar. And then there is a climate, what we are talking today, in particular, a comparative laboratory to delve deeper into the challenging issues of corporate climate litigation, so what we call the Corporate Climate Litigation Toolbox. And this is just to show you the CCL resources. As I told you, is a literature repository established, growing with the support of our international expert group. And we have, as you see, references to books, to journal articles, to reports, but also webinars, podcasts, and blogs in the field, all the knowledge on this fascinating and critical field of litigation. And then, of course, as I said, the CCL Toolbox is the 3rd part of our platform, where you find the global toolbox on corporate climate litigation, where you find the 70 national reports that have been that were already published online a few months ago in March, and also the national conferences and regional summits recording and materials. So we will find everything there. You see here just another screenshot of our national reports webpage and the covers of the excellent Asian reports published in March. So these reports, as I said, are the fruit of the discussion and the contribution of experts from very different fields of law, academics, practitioners, and also scientists in all the countries examined. And of course, I encourage you to download these reports directly from the BIICL website and enjoy the work that is a collaborative task of our great experts. So yeah, this is just the last part. You see here some screenshot of the Global Toolbox on Corporate Climate Litigation. Our analysis said encompassed 17 countries from every continent and is founded on 3 main axes: causes of actions, procedure and evidence, and remedies. As you can see on the right-hand side of this slide, we have explored the possibilities related to the most critical causes of action to be used in this kind of litigation. So you see we have, we go from climate, environmental or statutory provision to human rights, tort law. There are 10 sections on tort, and many others. We have consumer protection law, contractual obligation, planning, and permitting laws, among the others. And we have also explored the most relevant procedural evidentiary elements in this kind of litigation, as you will discover during these 2 days, including legal arguments and defenses, issues of justiciability, jurisdiction, group litigation, apportionment, cost, many others, and of course, the possible available remedies. As you can see on the right side of the slide, the toolbox structure offers legal models, authoritative references, and strategic insights. And on the BIICL website, you will see that most of the toolbox section follow a similar structure. We will have an overview, a graphic summary showing the established legal avenues related, for example, to a cause of action or a procedural issue, the related hurdles that we find in the different legal system, and comparatively, and the potential legal avenues, so the prospects for these tools, let's say. And these are developed in more details through the analysis of case law in different countries. You will also find the main elements, essential definitions in relation to each topic. So this is part of our comparative work. And we will finish every section with the country summaries for each country. So it is important to highlight that this toolbox is not merely a platform. It is really a testament to global collaboration. As you will see in this Asian summit, discussed in very different perspectives, the legal system are varied, but our challenges are shared. And so just let me finish with our dissemination plans. In fact, as I said, the Global Toolbox is not static, but is an evolving platform developing through the ongoing dialogue with our international expert group, which keeps growing weekly, I would say, and includes new experts in many fields. And this dialogue's expansion continues until the end of the year through the 17 national conferences and 5 regional summits, which have been held, as you see, as hybrid events at partner university or other venues. And during all the events, we are trying, with the fundamental help of our excellent national rapporteurs, to include all the relevant stakeholders in the discussion, to test, provide feedback, and also to improve the toolbox. Next year, we will have also planned to enlarge to more than 70, the first 17 countries. As you can see on the slide, we are just halfway through our dissemination plans for this year, and I'm really proud to introduce the work of our Asian Summit in the Philippines. And before leaving the floor to the first keynote speaker, I would like really to thank once again Professor Mike Tu and the great team at the University of the Philippines College of Law, our excellent team of Asian rapporteurs and the other speakers, as well as Chris Bernardino and my other colleagues at BIICL for organizing this summit, which promises to be exciting and memorable. So do not hesitate to contact us and join the Global Toolbox project. Thank you again, everyone, and have a good day.
Thank you very much, Dr. Alogna. Indeed, corporate climate litigation is looking to be an important and collaborative field of litigation.